So good morning everyone, my name is Lalit Soni and I welcome you all in this live session by Drishti IAS. As usual, we will be taking a look at today's Indian Express newspaper. Since there are very important issues to be discussed today, as you must have heard that the Supreme Court has struck down electoral bond scheme. So basically our session today will be more focused on that because there are 3, 4, 5 articles in this newspaper related to electoral bond. So mostly our discussion will revolve around that. Other than that, we will take up 2 or 3 more articles, that is one is related to self-sufficiency in pulses. You know that India is trying to be self-sufficient in food grains, okay, and pulses is one of that component. When we are talking about pulses and oil seeds, we know that India is quite dependent on imports, okay. So right now we will be talking about pulses and we have a target that we will be being self-sufficient by 2027, okay. So we will be talking about that article and then quiet diplomacy in Qatar case, okay. So we have talked about Qatar case again and again, but we will take a diplomatic angle, let how this change in the judgment, or you can how we have actually reversed the judgment from death sentence to acquittal. So basically we will be talking about this, that how quiet diplomacy worked in Qatar case, though in the article they have talked about Prime Minister visit in Qatar. So we will be taking up that article too, okay. Then we will be talking about some news from the around the world. When we are talking about Pakistan, etc., Pakistan, UK, Japan, there are some articles, we will be talking about that. And then there will be one article for your own read, because when we are talking about electoral bond, we have discussed most of the article, we have taken the crux out of all the articles, but the thing is still I would want you to read one or two articles related to that, okay. Then we will start with the practice question. Before that, let's have a look at the front page of the Indian Express. Supreme Court lets the sunlight in. So basically, whenever there is a excess of polity, or you can say politics, or maybe you can say excess of executive, then Supreme Court can basically put a balance on that, basically put a check on that. We know that we live in a system wherein check and balances are there. Every organ of the government keeps a check or balance on the other one, okay. But most of the time you have seen that judiciary has been active in that regard. So basically right now we will be talking about a judicial review of electoral bond scheme. We will be talking about that petition in a you can say very specific manner in today's discussion. There are these 1, 2, 3, 4 articles related to this. We will be discussing the crux out of it, okay. So let's start. First we will see the practice question which was given to you in the last class. Mayotte is located in which ocean? So basically this island is basically belonging to, or you can say it is a territory of France in Indian Ocean region. So answer would be C. That is one thing. We were discussing about it because of the some citizenship related issues. When we are talking about Mayotte territory of France, France has this you can say way of giving citizen. There are two ways France gives citizen, that is one is parentage and second is on the basis of birth, okay. So basically when we are talking about this parentage situation, in this case Mayotte island, they have said that there won't be giving any citizenship based on parentage, I'm sorry, citizenship based on any birth, okay. So until unless you have your parents living over there or parents being citizen of France, you will not be getting citizenship, and that is because of some issues related to immigration, okay. We have discussed it in the yesterday's class. So right now we will be having a look at the location of Mayotte. Here you can see that this is the location of Mayotte in the vicinity of Madagascar in the Indian Ocean region. Now second thing is, this migration issue is because of people migrating from Comoros to Mayotte, okay. So that is why this particular island has been in news. So we are talking about it right now, okay. Now moving further, and we will start with the first article of the day, that is related to your Supreme Court's judgment on electoral bond. We have talked about electoral bonds, what are electoral bonds, why they were in news, why there are some issues regarding that. So we will not go into details of electoral bonds, or we will not go into details of what were the issues regarding it. Today's focus would be on the judgment, but for your reference I would give you 1 or 2 slides from where you can see what electoral bonds are and how they work and what are the issues regarding that, okay. And I will give you a passing reference as well. So let's see the page. These are some news articles which I have picked up from the newspaper, and then we have gone through it and then make some crux out of it, and we will be discussing that, okay. So Supreme Court lets the sunlight in, upholding citizens' right to know. So basically when we are talking about electoral bond scheme, there was this clause of anonymity. You cannot know who the donor is, ultimately you can say that a person or a citizen would not know who the donor is, but SBI would know. The bank which is giving the electoral bonds, they would know. Now SBI is the government body, and ultimately you can say that in any case, if government is asking SBI to furnish this information to government, they have to do it. So ultimately the party which is in ruling, that will get some benefit out of that. So that is why there was this issue that information of donor will be anonymous. So basically a citizen who is voting would not know that what kind of political funding his candidate is getting. So that is why there was this issue related to citizens' right to know. So now Supreme Court has said that this right would prevail and this scheme has to go. Okay. Upholding citizens' right to know, court strike down electoral bond scheme, secret funding of polls. So basically, as I told you, there is a clause of anonymity. Right to information about candidate applicable to political parties. Okay, so they are saying that even to the political parties, right to know about the candidate is a fundamental right of a citizen that is given under Article 19(1)(a). Okay, then court says permitting unlimited contribution violates free and fair polls. Unlimited contribution here means is that when we are talking about an individual, he has a limited capacity to contribute. Okay, but when we are talking about big multinational companies, or we are talking about big capitalist houses, these have unlimited capacity. They can give a huge amount of funding to them. But the thing is, when they are giving something, they would want something in back. Quid pro quo. Basically, wanting something for something. So basically here court is saying you cannot allow such unlimited funding from big corporate houses, because ultimately they will influence the policy making. So that is another thing. Third is scheme not least restrictive in nature. The aim of the scheme was to curb the black money. Okay, so that is why we Arun Jaitley in 2017 come up with this scheme in the parliament, but the aim was to curb the black money. But the thing is, here they have not gone for the least restrictive approach. Here what they mean is that when we are talking about any kind of legal objective where we want to do something, okay, let's say curbing the money laundering, etc., or you can say curbing the black money, in that case also you should restrict minimum fundamental right as possible. Right now they are saying that they have restricted right to know, but the thing is there are alternative ways in which that can be done. You don't have to just go for a restriction of fundamental right under 19(1)(a). So basically here Supreme Court says that it is not least restrictive way. There are other ways in which even fundamental right might not be hampered, and you can still go towards the objective of curbing the black money. Okay, so these are certain things which Supreme Court has said. Other than that also, when we are talking about the bench, it was a 5-judge bench, you can say, and it was presided by CGI D.Y. Chandrachud, and they have talked about proportionality. There is a doctrine of proportionality, we will be talking about that as well. Okay, and then there are certain articles related to Supreme Court draws new red line. Burden is on the state to be least restrictive. When we are talking about going for any state objective, in that case you should be least restrictive of fundamental rights. Okay. Second is Supreme Court orders SBI to give details of bond to EC, set March 13 as deadline. Now Supreme Court is saying all the information which SBI holds related to the donors, they have to give it to ECI, so that free and fair elections could be you can say performed. Because the thing is, if a particular donor is giving a lot of contribution to a particular party, that means that if he is a capitalist or if he is from a particular multinational company, they would want something in back, and that is why Supreme Court has said that furnish all the data to ECI. Okay. Now perfect has become the enemy of good. They were trying to become perfect, but the thing is, in order to do that, they have actually restricted the fundamental right, and so ultimately we lost the good as well, because this scheme objective of scheme was good to curb the money black money, but the thing is, in order to be perfect, they went anonymous, and then ultimately it harms the objective. Okay. Now respect the court says BJP aims for scheme was transparency. So basically they are saying that the aim was going for transparency and going for curbing the money laundering, but still they are respecting the court's order. Obviously they have to. And second last article was judgment has restored level playing field for all parties. Opposition welcomes the verdict, hopes to flag quid pro quo as whole point. So basically, as I told you, quid pro quo means that something for something. Like if there is a capitalist, he would fund your political campaigning only if he is gaining something back in return, because capitalist, or you can say when we are talking about businesses, they run on profit by any means. Okay. So now even oppositions are saying that this judgment has restored level playing field, because when there is this anonymity related to the donor, and since SBI was a government body, there are chances that more of the funding was going to the ruling party, and in this case also, when we are talking about, nearly 57% of the funding has gone to a particular party. Okay, so that is why this particular judgment was important. So now let's come and look into details of it. Okay, hold on. So electoral bonds, when I told you I will be giving you a passing reference here, it is, they are interest free bearer instruments, or they are kind of a promissory note which citizen or corporation can purchase from the State Bank of India and donate to a particular political party, and these political parties can actually go for encashing in the 15th days. Okay, so it is a money instrument like a promissory note bought by companies and individuals, and it is given by State Bank of India. So State Bank of India is only body which is authorized to give it. Okay, they can sell the bonds in the denomination of 1000, 10,000, 1 lakh, 10 lakh and 1 crore, and can be bought by a KYC compliant account. Okay, so they will have the information, because know your customer norms are being fulfilled here. So SBI will have the information of the donor. Okay, and donated to a particular party, which can then encash them in 15 days. Name and other details of the donor are not entered on the instrument. When we are talking about that particular bond, on the bond these details would not be there. Here you can see, this is the bond. Okay, so there is just the date, because we know that this date is important, because in 15 days you have to encash it. Okay, and the denomination, the number of, or you can say amount which has been donated. Other than that, you don't see any kind of information about the donor. Okay, so that is how electoral bond look. Okay, there is no cap on the number of electoral bond that a person or company can purchase. Okay, you can go for unlimited number of bonds you can purchase from the SBI. Okay, now moving further, every political party who is registered political party under 29A of RPA, Representation of People Act, at least 1% vote that party should have got in the last, or you can say latest Lok Sabha election or state elections. So ultimately, if a political party who is registered under section 29A and they are getting at least 1% vote in latest election, in that case you are eligible for electoral bonds. Okay. Second thing is, the bond amount can be deposited within 15 days after issue, that is, you have to encash it within 15 days. If you don't do it, then that amount will be directly deposited to Prime Minister's Relief Fund. Okay, so that was a good part in that. Now moving further, coming to the legal challenges or the petitions. Okay, there are various issues related to it. As I told you, there are issues related to transparency and accountability. When we are talking about this process is opaque, because there are clause of anonymity, so we can say that this process is kind of opaque. So there was issues related to transparency. Then right to information, as I told you, that was curtailed. Okay, so that is another thing. Third thing is anonymity in the donations. We have seen that, and it favors the government, because government, when we are talking about government, it is basically a political party in rule. Okay, so ultimately when we are looking at the data, it says that 57% of the funding has gone to BJP. Okay, and to the opposition party, that is Congress, it has only got nearly 10%. So we can say that it will somehow favor the government, because obviously there are apprehensions that government might get the data, and if government is getting the data and government is anyhow knowing that who has given money to whom, in that case that donor would be at risk. Okay, so that is why, even though government is not having that data, it is just an apprehension. Even in that case also, people on the basis of apprehension or speculations, they will donate to the party in ruling. So that is why you can say that that will favor the party who is ruling at that point of time. Okay, now emphasizes the risk of companies funneling money without shareholders consent. When we are talking about that, these bonds can be purchased by the MNCs or any company as well, or a corporation as well. Now corporation will not go and ask shareholders that whom do you want to support. Okay, they will do it on their own choice. So ultimately they will not ask consent of shareholders. Okay, so ultimately that will potentially neglect the shareholders right. So these are certain issues because of which few parties, or you can say Communist Party of India, Marxist, NGO that is named Common Cause, and Association of Democratic Right, that is ADR, they have gone to Supreme Court. Now when we are talking about Common Cause and ADR, mostly in the case of political reforms etc., these are the NGOs which are working in that direction, and they goes to Supreme Court for various petitions etc. So that is a legal challenge which has been posed, and now that thing gone to Supreme Court, and Supreme Court gave their verdict after a long time. So we'll be talking about that verdict now. Now first thing, Supreme Court says that it is a violation of right of information. Obviously a person who is voting, he must have a right, who voted his candidate's political campaigning. Okay, so that is one thing. So when we are talking about any kind of political affiliation, or when we are building a political opinion about something, we should have information for that. And in this case Supreme Court is saying that it is right of a citizen to know about their candidate. Okay, scheme infringes on the right to information under Article 19(1)(a), as voter must have access to the details about funding of political parties, which is essential for voting. So that is for the political parties or the political individual, for them they are voting. So basically they should have information about that. So that is one thing. Now here how it is violating, because they are not giving the details of the donor here. So that is one thing. Now restricting the right of information to curb black money is not a valid reason. Now they are saying that we have done it for the transparency, and we have done it for the curbing the black money in the circulation. Now government is saying that you have to take a less restrictive approach. You cannot, on the basis of just this objective, you cannot say that you can violate a fundamental right. Okay, so fundamental right prevails in the most of the situations. Other less restrictive means could have achieved without infringing the fundamental rights. That is the observation of Supreme Court. Court has relied on the proportionality test, which has been laid down in 2017 in K.S. Puttaswamy, that is privacy judgment. You must have heard about it. Otherwise also this judgment is very important for you if you are preparing for any kind of civil services exam. So that judgment is kind of important for you. K.S. Puttaswamy judgment of 2017, and that is important because of the issue related to privacy. Okay, so in that particular judgment, proportionality test was laid down, and we will be talking about that test in the further slides. And in this case also Supreme Court has relied on that particular thing. Okay, for the scheme to be considered legitimate, government scheme would have essentially satisfied three aspects. These three aspects are basically the test of proportionality. Okay, the proportionality test is a legal principle used to determine whether action of the government or law are appropriately balanced with the infringement of the individual's rights. So basically they will be seeing executive action or the action of the government or law is in balance with the fundamental right or not, or if they are infringing the fundamental right. So ultimately this is the principle to check the balance between fundamental rights and any executive action. Now there are three steps there on the basis of which a court will decide. As I told you, there are three aspects. So these three aspects are: one is if it is based on a legitimate objective. Okay, when we are talking about any law or a scheme, so there should be a legitimate objective. Okay, so basically here objective was to curb the money laundering. Okay, sorry, black money. So one thing is that, okay, fine, there was this objective. Now there was this existence of law with a legitimate objective. So that step is fine. Now legitimate state interest should be there. State interest means, or you can say there should be a government's objective behind it, and government should be working in that direction directly or indirectly. So that is one thing that is also there, because government try to work towards it. Now is necessary and least restrictive means, was it necessary to do that? Or second thing is, was it the least restrictive means, or otherwise it is not violating any fundamental right unnecessary. So when we are talking about this particular aspect, here there was a fault in that particular scheme. Okay, so let's see how Supreme Court has seen it. Supreme Court has said, is there a law? We said yes, there is a law on the basis of which these electoral bond scheme came. You know that it was entered through a Finance Act in 2018. Okay, now is there a legitimate state interest? Yes, there was a legitimate interest related to curbing the black money and protecting the donor privacy. Okay, since we are not giving away the details of the donors, so we are protecting the donor's identity here. Okay, Now third is restriction proportional. Here court has said that no, these restrictions were not proportional because there are other means by which you could have done it. Okay. Now why this scheme failed? Not the least restrictive method. As I told you, it is not the least restrictive method. Transparency versus black money. So when we are talking about anonymity may curb the black money, but it severely hurts the transparency, a fundamental right of the citizen. So basically here they are going for a test between the objective and the fundamental right, and now Supreme Court is preferring the fundamental right, and which should be the case. An alternative option exists like stricter reporting requirement for larger donations. So if you are going for a strict requirements by the political parties that you should give the details of the larger donors, in that regard you could have actually achieved your political objective, or you can say state objective of curbing the black money. Okay, so there were other options as well, but that was not actually used, and they have gone for the restricting the fundamental rights. That is why ultimately on the basis of all these observations, Supreme Court has actually struck down this particular scheme. Okay, other than that also there were few observations which were made. Hold on. Other than that also there were few observations which were made by the Supreme Court, that is related to unlimited political contribution by the companies. As I told you, big corporation house or big capitalist parties, they can go for larger funding, and in return they would want some kind of advantage out of it or some kind of policy measures. Okay, so here court said that this cannot be permitted. These larger, or you can say unlimited political funding or unlimited donations, that cannot be permitted, because ability of companies to influence the political process through contribution is much higher compared to the individual. When we are talking about an individual, let's say a student, a lawmaker, or maybe a professor, so all these people have a limited ability to contribute to political funding. But when we are talking about big fundings or big giants like companies, etc., they have ability to influence the political process. Okay, and that is why they can even donate larger to achieve their own goals. Okay, the contribution made by the companies are purely business transactions made with the intent of securing benefits in return. So basically they would want certain benefit, so that is why that cannot be permissible. So that is why they have struck down the this particular scheme. Other than that also, justification for infringement of the donor privacy. Okay, so here they have said that there is a right to privacy to the donors. Yes, okay, donors privacy should be maintained, but the thing is that right should be given to the individual donors and not the larger companies, etc. Because there are 2-3 reasons. One, when we are talking about larger companies, we have seen that they have power to influence the political process. Okay, one thing. Second thing is, when we are talking about larger companies, there are other shareholders as well. Okay, so let's say if I am a shareholder, or I am a group of shareholders which are not in favor of a ideology of a particular party, but now company is supporting that party. That way the money of shareholders is utilized in a different manner. Okay, so consent of the shareholder is not taken in that case also. So ultimately in that case, when we are going for a larger donor or any kind of company which is donating, so their identity should be placed in front of the citizens. Okay, so that is about this justification of infringement of the donor's privacy. And when we are talking about individuals like a lawmaker or a student or a small group of people, in that case you can maintain the privacy. Okay, now overall this was the judgment. Okay, we have discussed every aspect of it. There is nothing beyond that. You should refer. If you are understanding this much, that is enough for this particular judgment. And now there are certain summaries which are given and which has been taken from the newspaper itself. So you can read it if you want. Otherwise, this particular discussion was fine. Now we can move to the another article that is related to your effort being made to attain self-sufficiency in pulses by 2027. Okay, so now this was said by agriculture minister, okay, Arjun Munda. He has said that we are trying to achieve self-sufficiency by 2027. So there are certain observations which has been made by him on this particular convention, that is Pulses Convention 2024, which has been organized by Global Pulses Confederation, GPC, and the NAFED, National Agriculture Cooperation Marketing Federation of India Limited. Okay, if you want to remember it, it's okay. Otherwise also there is no need. Okay, now he has said that government is also consistently striving towards increasing the domestic production of pulses to gradually reduce dependency on the imports and move towards self-reliance in the pulses. When we are talking about pulses and oil seeds, in these two regards we are kind of dependent on the imports, okay, but we are trying to go for self sufficiency in those two both of these things, okay. Other than that, also here we can say that observing that India has become self reliant in chickpeas, okay. So when we are talking about chickpeas or other few crops like you can say pigeon peas, black grams, etc. So in chickpeas we have attained the self reliancy. When we are talking about pigeon peas and black gram, in that we are still a little bit behind from achieving the self sufficiency, but we will do it in a very small time now, okay. So that is one thing. On the similar lines, we are saying that we will be going for self sufficiency in pulses by 2027. So that target becomes important for you, okay. Self sufficiency in pulses by 2027, okay. Now production of pulses has increased from 16.32 million metric tons to you can say nearly 26 million metric tons in you can say last 7 to 8 years, okay. So from 2015-16 to 23-24, this is the you can say increase in the production. So we are going in the right direction. Still we are lagging behind from the domestic demand, okay. There is this Bharat Chana Dal has captured 25% of the retail market. Now when we are talking about this Bharat brand, so this brand is being developed by government, and now government is entering into retail market. Why? Because just to curtail the inflation, most of the time you say because of the hoarding or because of the storage etc. There are artificial inflation in the market because people are storing in their godown, so that there is artificial demand in the market, because of which prices may rise and then they will sell their products, okay. To avoid that, government is going for the retail marketing, and here we are going for the Bharat brand. You must have heard about this Bharat Chana Dal which we are talking about. Other than that, Bharat rice is there. Other than that, there is this Bharat fertilizer is there, okay. For all these regards, you can say that Bharat is going for making their own brand. There are certain Western economists, they would say that government should not enter into business of business, or you can say that government should not enter into any kind of you can say business in the market, okay. Most of the time Western countries says that it should be left on the markets and the market forces, that is that generally we call invisible hand, okay. That concept has been given by the Adam Smith. So concept of invisible hand is that government should be least interfering in the market, and market should derive or decide the price of certain things. But the thing is, Indian economists or the Indian authorities are saying that in case if there is a requirement wherein customers are suffering because of certain things, okay, then in that case government can go into that arena, okay. So right now we are going into Bharat brand because of the inflation related issues. So here Bharat Chana Dal has captured 25% of the retail market already, okay. Other than that, when we are talking about minimum support price, so there is a minimum support price for pulses as well, which has been decided or we can say advised by CSCP, and ultimately government announced the MSPs, okay. Here we have discussed about Bharat brand pulses and wheat flour, okay. So here we have discussed the reason behind it, why should government enter into this particular arena, okay. So that is about this article which we have discussed. There is one important fact that is related to self-reliance in pulses by 2027. Other than that, what is important is that Bharat brand, government is going to retail trading now. Now around the world there are certain news. When we are talking about this Qatar case, you must have heard about this case, and we have discussed it that there was some 8 ex-Navy personnel which has been arrested on the charge of espionage. Though these charges were not made you can say public, they have said that because of the sensitive issue, sensitive nature of the case, which you can understand, because if someone is getting death penalty because of certain particular action, so it means that there were some very high degree of charges were there, okay. But the thing is, these charges were not made public because of certain sensitive issues, and then they were given death sentence, Okay, after that, that death sentence was commuted into lesser imprisonment, but recently the court in Qatar has given a clean chit to these Indians and they have been sent back to India. Most, 7 out of 8 people has been sent back to India and one person is there left for the formalities and he will be sent back later. Now the thing is how this happened from death sentence to commuting the sentence and then to you can say even at the word of you can say acquittal. Okay, so now the thing is behind all these things there was a diplomacy, or you can say behind all these things there was government efforts or diplomatic channels of the government which were working very fine. Here we can say that that is a successful example of quiet diplomacy. Quiet diplomacy means that we can say that behind the curtain negotiations. Most of the time when we are talking about some international issues, they are talking in the public, they were being talked in the public domain. When we have talked about Kulbhushan Jadhav case in Pakistan, so when that case happened, in that case we have gone to even international bodies, okay, and we have said that Pakistan should give us the consular access, etc. Okay, and there are certain international law that should be followed. When there was this case related to Canada, okay, there was this allegation on Indian government involvement in the killing of this Hardeep Singh Nizar, okay, and that point of time also India has taken very harsh stand and we have said that nearly 40 diplomats of Canada, they were sent back to their country. Okay, and the ties, there was a time where relations between India and Canada was on a bitter edge. Okay, but the thing is when this thing happened in Qatar where 8 people were given a death sentence, we did not take any harsh action. We have gone for the quiet diplomacy here. These talks were not held in the public domain, charges were not made public, and then all the discussions were made behind the curtain. You must see that the day even the Prime Minister himself has been involved in all these things. He has met with Qatar's Amir in COP20 sidelines of the COP28 as well in the Dubai, and then also afterwards also you must have seen after this sentence was reversed, then Prime Minister has visited Qatar recently. You must have seen in this picture. So ultimately we can say that all these things happened behind the curtain. There were some negotiations which has happened behind the curtain, and that is what quiet diplomacy is. Okay, so here you can see quiet diplomacy refers to one state's effort to influence the behavior of another state through discreet negotiations, discreet or you can say covert negotiations or actions. This means operating behind the scenes, operating behind the curtains, and may rely on back channeling rather than on public talks. Okay, so that is what we have discussed, that is quiet diplomacy. Now coming back to the article, PM thanked Qatar Amir for release of ex Navy personnel which has been given the death sentence. So he has met with him and then he has thanked him, and now they have been talking about further increasing our bilateral ties. Okay, more than 3 months after they were sentenced to death, 8 former Indian Navy personnel were released from the custody in Qatar. MEA said Modi also thanks the Amir for taking care of nearly 8 lakh strong Indian community in Qatar. Now the thing is India is kind of providing services over there. There are nearly 8 lakh diasporas which are living over there. They are sending remittances. So that is why Qatar is important for us. Other than that, when we are talking about energy security, Qatar is important for us. Other than that, when we are looking at the situation in the Middle East, Qatar has been a very significant player in that. So that is why also Qatar is important for us, because we have this India, Middle East, Europe economic corridor. So that region becomes important and players in the region are quite important. When we are talking about Qatar, Qatar can be seen as a swing state. We have talked about swing state in our previous sessions. A swing state is a state which is a smaller state. It is not a big state, but it has influence, or you can say it has a say in the diplomacy of that area or in the geopolitics of that area. Okay, so Qatar has been a country which has been in talks with Israel as well as Hamas. Okay, hold on. So that is why Qatar is important, because there are 8 lakh Indian people living there, and conveyed India's commitment to further expanding and deepening bilateral cooperation. He also invited Amir to visit India. Okay. Other than that, when we are talking about, the two leaders exchanged view on expanding bilateral cooperation in sectors like trade, investment, energy, finance and technology. Earlier when we are talking about the nature of business or nature of relations with Qatar or any other Arab country, most of these relations were you can say transactional in nature. Transactional relations means that same thing, just based on the economy, you will we will import or export things. There were no political or you can say people to people connect at that point of time. Okay, but then in the recent last 10 to 15 years, we have seen that there are people to people connect. There are people living over there, and in the, if we see in the broader Arab countries, so our relations has improved in the past, and now these countries are going for diversification of their economy, and that is why India becomes important for them as well. Okay, they have money, they have capital, and India wants that capital for investments. Okay, they have capital because of their natural resources like hydrocarbons or oil, etc. Okay, now India want that capital for investment. On the other hand, Qatar or other countries like UAE, etc., they want India's support in various sectors, like let's say finance, technology, or technology in the broader sense. And so that is why there are certain areas, that is trade, investment, energy, finance, and technology. Okay, they also discussed the regional developments in the West Asia and emphasized on the importance of upholding peace and stability in the region and beyond. As we are talking about Israel Hamas issues, they have also talked about that. So with that, that article completes, and that one thing which is important from this article is that term quiet diplomacy. Now moving further, Pakistan top court seeks assurance from government of military's exclusive focus on defense matters. When we are talking about Pakistan, okay, in world over it is said that every country has a military of its own. Now Pakistan's military or Pakistan's army is the army which has a country of their own. So when we are talking about Pakistan, military is so powerful that if there is an arena, or if there is you can name a sector, and military is having a presence over there. Even in dairy sector, even in going for marriage hall, etc., they have their presence. Okay, so in Pakistan, military is a very strong establishment as well as a business establishment. So right now Supreme Court has said that, or they have said, asked assurance from the government that government should ensure that military restrict themselves to the defense sector only. So why this happened? Because there was this case wherein they have acquired some land from people, saying that it is for strategic operations, but then on that particular land they have made marriage halls. Okay, so that is the kind of nature you can say Pakistan has, or that is the kind of economy, or you can say political institutions Pakistan has right now. Okay, they have taken land from the people on the lines that they are going for any strategic actions over there, or strategic need of the government, and then they have made marriage halls over there. And that case come to the Supreme Court of Pakistan, and Supreme Court of Pakistan has said that government should ensure that these military establishment only restrict themselves to the defense matters. Okay, so that is one thing. Other than that, Imran Khan has asked for support from USA, as USA is the champion of democracy, and Imran Khan is saying that there was allegedly some malpractices which has been used in Pakistan's elections. Okay, so there are certain things which are related to Pakistan which we have seen now. Now moving further, there is this economy related article, or you can say there is this when we were talking about geo economy, so there was this article related to UK and Japan. Now UK and Japan are developed countries, but right now economy doesn't sound good for them, because they are going into a direction of recession. Okay, so here you can say that UK and Japan slips into recession. Now we are not going into data like how much was the slip, etc., because that is not relevant for us. Just know that these economies were developed and now they are going for the recession. Second thing is, now there are elections in UK as well, so there that might have impact on that as well. Okay, third thing is, when we are talking about Japan, Japan was the third largest economy in the world, which has been fourth now, and Germany has become the third, because there was this recession thing which was going on over there. Japan unexpectedly slipped into recession at the end of the last year, losing its title as the world's third largest economy to Germany. Now we are seeing that Japan has this ultra loose monetary policy, wherein Japan give loans, or even Japan pays interest if people are taking loans. Okay, so ultimately they have this negative interest rate in Japan. So you can say that this is ultra loose monetary policies. Now we are saying that there are chances that there might be a reverse in that, but still we are not sure. That's just speculations. But the thing is, one thing is clear, that is Japan and UK are going into recessions. Okay, now when we are talking about Japan, why this recession is there? Because Japan, the domestic demand is slowed down. Other than that also, when we are talking about China, that domestic demand in China is also actually being on the declining trends. Okay, so that is why in Japan, you can say in Japan, some analysts are warning of another contraction by next quarter. Weak demand in China, sluggish consumption and production holds you can say a point of challenging path to economic recovery. Okay, so there are certain things which we have talked about. When we are talking about recession, recession means here that if in the 2 consecutive quarters, if you are going for contraction, if in economy for 2 consecutive quarters you are going for contraction, or you can say your GDP or your economy is contracting, then you can say that it is recession. Okay, so that is the term which is used in economy, which you should remember. So that is about this article. Now we can move to the article for your own read. Now we have talked about electoral bond, we have talked about the judgment, we have said that electoral bonds are now being struck down. But what lies ahead? What can we do about political funding? What can we do about disturbing black money? In that regard, there is this article where is different, you can say, aspects has been discussed. They have given some way forward. They have also talked about various practices in different countries. Okay, so from that experience you can talk about it. Okay, so you can go and read this particular article, which is important, I would say. Okay, now moving further, there is a practice question for you. What does proportionality test evaluate in the context of state action? We have talked about proportionality test, that is from the Puttaswamy judgment of 2017, you can say. Okay, options are the financial impact on the action on the state's resources. Then second is the action of effectiveness in the action's effectiveness in achieving its legislative goal, whether the extent of the state's encroachment into rights is justified by its objective, and the last option is the public's opinion on the state's action. So now you can attempt this question, because we have discussed proportionality test. There are 3 aspects, we have discussed all of them. With that, I would like to take your leave. If you have not subscribed the channel, please subscribe the channel, and I'll see you in the next session. Till then, thank you. Have a good day.